Hello, welcome back to this channel if you are watching this. So, a very huge welcome to you. As if this is your first time you are listening to this video, I had started, for your information, I would like to tell you that I had started this series for current affairs from last 1 year. Right now, I am discussing the current affairs of polity and governance. This is the eighth discussion regarding that. You know, from last 7 classes, we had discussed what was in the news from last 1 year. Almost every important article which is important for your UPSC or your state civil services, that would be discussed here. Now we have few more lectures for this subject. Then we would move towards current affairs of international relations. Without wasting any time, let's move to the topic. Today, we are going to discuss almost 6 to 7 topics, of which the most important are as follows. Let's begin with our first topic. It is about capacity building of urban local bodies. It was in news recently. Let us discuss about it. Let us see what urban local bodies are, and let us discuss a little bit about capacity building commission in relation to your UPSC exam. As it is mentioned in the slide, capacity building commission in collaboration with the Ministry of Housing and Urban Affairs organized a national workshop on capacity building of ULBs, urban local bodies. The workshop marked the launch of three initiatives. Three initiatives were launched, which included annual capacity building plan with ACBP to enhance the capacities of Ministry of Housing Urban Affairs. Then we have an annual capacity building program for 6 pilot ULBs. They are as Ahmedabad, Bhubaneswar, Mysore, Rajkot, Nagpur, and Pune. And what is the other initiative? Comprehensive toolkit for preparing capacity building plans for ULBs. It was brought out for providing valuable resources to facilitate the growth and development of ULBs. So these were the three initiatives which were brought in. If we would summarize it, it would be as annual capacity building plan, then ACBP for 6 pilot ULBs, which include Ahmedabad, Bhubaneswar, Mysore, Rajkot, Nagpur, and Pune. Then we had toolkit for preparing capacity building plans for ULBs to facilitate the growth and development of ULBs. Now let's move to the other slide. It talks about urban local bodies. Let us see what urban local bodies are. ULBs are small local bodies which administer or govern a city or a town of a specific population. So if we would know, if it would be asked in which part the urban local bodies or local governance comes, it comes under the list and under state list, which is entry 5. And also Constitutional 74th Amendment Act 1992 formally recognized urban local governments as the third tier of government. This act provides for the establishment of 3 types of ULBs, which include Nagar Panchayats for transitional area, municipal councils for a smaller urban area, and municipal corporation for a larger urban area. So what did we learn in this slide? Uh, it is about urban local bodies are small local bodies that administer or govern a city or a town. It is under the part and under entry 5 of the state list, and 74th Amendment 1992. It gave the formal recognition to the third tier of the government, it as the third tier of the government. This act provides for the establishment of three types of ULBs, as we discussed: Nagar Panchayats for transitional areas, then we have which are in transition from village to the town, and then we have municipal councils for a smaller urban areas, and municipal corporation for a larger urban areas. So these are the main points in it. Now move to this next slide, which is the need for capacity building. We have need for capacity building. What is the need for this, for the capacity building of urban local bodies? We can summarize it in following points. For the regional aspiration, for example, to deal with the regional aspiration, that is economic and social development through bottom-up planning. For economic and social development through bottom-up planning. Then we have India's urban centers are considered engines of growth, as they account for nearly 2/3 of the country's economic growth. That is a huge point. They are considered as engines of growth. And also India's urban population is expected to almost double from 460 million in 2018 to 876 million by 2050. So this is very much important. So much population growth is going to happen, and we need to develop the capacity building of urban local bodies. And for implementation, for successful and effective implementation of schemes like Smart City Mission, Amrut Mission, etc. For these points, for these points mentioned here, if we categorize it broadly, that for these points we need to build the capacity of the urban local bodies. If we would repeat it, it would be regional aspiration in shorter terms for economic and social development through bottom approach, urban centers considered as engines of growth, population expected to double from 400 million to 800 million approximately by 2050, and implementation of schemes. Now let's see what are the measures taken for capacity building of urban local bodies by the government. We have capacity building scheme for urban local bodies. It aims to strengthen urban local government through capacity building for better governance and financial management, as articulated in the 11th 5-year plan, as mentioned in 11th 5-year plan. Capacity building scheme for urban local bodies. Its aim is to strengthen urban local governments through capacity building for better governance and financial management and better financial management. Then we have World Bank assisted capacity building for urban development project. Here what we are discussing, it is the measures which are taken by the governments regarding the capacity building, or the organizations regarding the capacity building of the self-governments or local governments. We have urban World Bank assisted capacity building for urban development project. Its objective is to build the capacity of selected ULBs, which are centers of economic growth, in this World Bank's assisted capacity, there are selected ULBs, urban local bodies, which are centers of economic growth in those to improve their skills for better urban management and reduce urban poverty. Then we have National Urban Digital Mission, launched in 2021 by Ministry of Housing Urban Affairs. It focuses on citizen-centric digital revolution in urban local bodies in India. It aims to create a shared digital infrastructure working across three pillars of people, processes, and platforms to provide a framework for digital governance in the country. Then we have Jawaharlal Nehru National Urban Renewal Mission, which focuses on efficiency in urban infrastructure and service delivery mechanism. Then we have municipal bonds. So these are the measures which were taken to improve the capacity building of ULBs. Let us just summarize it. Capacity building scheme for urban local bodies. Then we have World Bank assisted capacity building for urban development projects. In it, few ULBs are selected, which are hubs for economic growth. Then we have National Urban Digital Mission. Then we have Jawaharlal Nehru National Urban Renewal Mission and municipal bonds. And then let's move to the challenges. What are the challenges in capacity building? We have lack of skills, training, curricula, lack of awareness and participation, and partial devolution. Lack of skills. The personnel engaged in managing urban affairs and municipal services lack specific skills, especially in areas like socio-economic planning. These skills are missing for a social economic planning, sustainable urban planning, financial management and governance, and etc. E-governance, these skills are missing. Then we have training curricula. Capacity gaps in municipal employees are augmented by capacity building deficits in the training institutions. These training curricula are program centric or event based, limiting their utility and further hampering the development of specific skills. We have lack of awareness and participation. The discontent between citizens and urban local bodies hampers effective communication. This cuts the feedback channel from the citizens, which could act as a key motivation for capacity building. People lack of awareness in people, that is one of the main challenges. Then we have partial devolution. The articles, for example, the Article 73rd and 74th Amendment Act enlisted the functions of local governance bodies. However, in practice, there is a lack of devolution of financial authority, resulting in local authorities having greater responsibilities without financial means to fulfill it. There are lack of finances to these bodies, but their duties are way ahead. So this partial devolution, it is also one of the main challenge in it. So this was about our first topic, which we discussed. Now let's move to the second most important article of today's discussion. It is criminalization of politics. Why was it in news? Analysis of sitting MPs from Lok Sabha and Rajya Sabha of India. This is the report which was released by Association for Democratic Reforms (ADR) and National Election Watch. If we discuss a little bit about ADR, which is Association for Democratic Reforms, it was established in 1999 by a group of professors from Indian Institute of Management and Indian Institute of Management, Ahmedabad, who brought it, a group of professors from Indian Institute of Management in 1999. So let us see what this criminalization of politics is, what this report discusses, what changes we have to bring in, and what are the changes government had brought so far, how constitution deals with it. Let us summarize this all in this topic, and let's move ahead. This brings us, what are the key findings in it? Sitting MPs with criminal cases 40%. As we see in this report, it is mentioned that sitting MPs in Lok Sabha and uh, in our parliament and state legislative assemblies, we have 40%. They have 40% of them have criminal cases, which they had mentioned, which they had brought out, which they had declared. Then sitting MPs with serious criminal cases like murder, rape, which they had brought out, they have 25%. And the data also brings and the state cities with highest percentage of sitting MPs with criminal cases in it. It was very much shocking for me too. This list, it is Lakshadweep is heading in it. Then we have Kerala, we have Bihar and Maharashtra. They have highest number of MPs having criminal cases, which have criminal cases against them. So these were the key findings of this report, which was brought out by ADR, which is Association for Democratic Reforms. If we would see what is the goal of the ADR, its goal is to improve governance and strengthen democracy by continuous work in the area of electoral and political reforms. So let us see what is the impact of criminalization of politics. It is, as mentioned, it can be broadly classified in following headings: institutionalization, corruption, and trust erosion. When we have these, when we have the criminalization of politics, political leaders, they, we can, if we would say it in layman's language, if criminals are represented in parliament, if they are representing the people, then corruption is bound to happen, and it would erode the trust that people will have on those political leaders. So it would uh, benefit the corruption and erode the trust, and it will have a very bad impact on the democracy, on the politics of the country. It would institutionalize the corruption. In it, corruption will thrive. Uh, people, crimes would be, crimes and criminals would be free and freed easily. There would be lack of cases against them, conviction would be very less, and because of the criminalization of politics. Then we have criminalization of political parties. This also leads to the criminalization of political parties because of the criminal elements can. This is because the criminal elements can gain control of political parties and using them for their benefits. And due to this, what would be the main concern? It would be the inner party democracy will also get adversely impacted. And also this leads to the effect, it affects the working of the investigation and prosecution agencies. Nexus between criminal politicians has a tendency to influence the working of agencies, as Supreme Court in 2017 termed Central Bureau of Investigation (CBI) as caged parrot and its master's voice. Then one of the most important impact, we can say adverse impact of it is decline in conviction rate, as per SC MX report. 5,097 cases are pending against lawmakers across the country, and also it would affect the conduction of free and fair elections. So it would simply, in simple words, it would hamper the democracy of the country. Now, what are the measures which might taken to check criminalization of politics? If we would say the legislative measures, for example, Section 8.3 of the Representation of People Act 1951. What does it say? It says any lawmaker sentenced to at least 2 years in jail remain disqualified for the cash in it. He would remain disqualified for 6 years upon their release. Upon their release, he would remain disqualified for 6 years after their release. That starting time would be. And such disqualification is enabled by Article 1021 of the Constitution of India, which says a lawmaker can be disqualified under any law enacted by the Parliament. Article 102, what does it say? Article 102 of the Constitution says a lawmaker can be disqualified under any law enacted by the Parliament. Similar provisions exist for states under Article 191. 1. Then we have judicial pronouncements, for example, Union of India versus Association for Democratic Reformers 2002. In it, SC stated that electors have a fundamental right to know the antecedents of candidates. It states right to be informed as a right flowing from freedom of speech and expression. In this Union of India versus Association for Democratic Reforms, the SC said that the voters or the electors had the right to know about the background of the candidate. In simple words, we can say it as we have right to be informed. Then we have Public Union for Civil Liberties versus Union of India 2004. In it, SC declared Section 33B of Representation of Act 1951 as unconstitutional and void. Why it was declared so? The section allowed candidates to furnish information only under the Act. Then we have Lily Thomas and Union of India 2013. In it, SC ruled that Section 8.4 of the Representation of People Act 1951 as unconstitutional. What Section 8.4 of the Representation of People Act deal with? Earlier allowed convicted MPs, MLAs and MLCs to continue in their post. This Section 8 this in it that SC reiterated the court's 2018 directions and directed the Election Commission to report to the Supreme Court any non-compliance by political parties. It directed Election Commission to report the Supreme Court. Way forward, it is lifetime ban for convicts from polls. Election Commission of India had mentioned it in the electoral reforms proposals published by it in 2004 and 2016. We have hybrid election system as suggested by the 170th Law Commission report on the hybrid election, that is 75% through first past the post and 25% through proportional system. Then we have punishment for Now we have parliamentary privileges of lawmakers. Recently, the Supreme Court set up 7-judge bench headed by Chief Justice of India for reconsideration of its 1998 5-judge constitutional bench judgment in the P.V. Narasimha Rao Commission (P.V. Narasimha Rao case). This 1998 judgment came in the backdrop of the 1993 Jharkhand Mukti Morcha bribery case. As per the judgment, legal immunity granted to legislators under Article 105 and Article 194 of the Constitution protects them against criminal prosecution on the bribery. Parliamentary privileges of lawmakers. This is one of the most important and sometimes most controversial thing in our Constitution. What are these parliamentary privileges? In it, the lawmaker, he is allowed to say whatever. He has the immunity against criminal and civil cases in the legislative assembly. He can say whatever. He has the extreme freedom of expression. So in it, he can vote according to his choice for voting in the parliament. He won't be tired. He won't be uh, prosecuted or punished for his acts in the parliament. So let us see what Jharkhand Mukti Morcha, what this. So in this case, what happened that the MP he took a bribe from another party and voted against the party whip, and he was freed. He under Article 105 as bribery was in by then Supreme Court judgment, which was 5-judge constitutional bench. They said that he is allowed to, he won't be prosecuted on bribery charges because he has he can vote in whatever way he wants to. So recently, this judgment, Supreme Court set up 7-judge bench headed by Chief Justice of India for reconsideration of its previous judgment. So recently, during these days, it gave it a judgment, and bribery has been totally banned and parliamentary privileges. Legal immunity enjoyed by members of the legislature, in which legislators are granted protection against civil and criminal liability for certain actions done or statements made in the course of their legislative What are the provisions here? We have Article 105 and 194. 105 deals with the powers and privileges of the both houses of the parliament and its members and committees. Similarly, Article 194 outlines the corresponding he doesn't enjoy any immunity against actions in a criminal case during the session or otherwise. Then we have right to exclude strangers. Members of the house have the power and the rights to exclude strangers who are not members of the house. So what is the need for the parliament for need for reforming the parliamentary privileges. If we would see in it applicability, the scope and limitations of parliamentary privileges are yet to be ascertained. In some instances, privileges shield lawmakers from prosecution as civil cases cannot be initiated when the House is in session. Then we have misuse. It is highly misused, misuse of powers and rights by the members of the parliament and legislative assembly. We have lack of oversight, lack of procedure in it against natural justice, and it also violates constitutionalism. The absence of codified privileges gives unlimited power to the House to decline when and how a breach of privilege occurs. Then we have third most important article. It is about interwater disputes. It was recently in news. The Union Cabinet approved the terms of reference to Krishna Water Dispute Tribunal to under the Interstate River Water Dispute Act 1956. Krishna Water Dispute Tribunal 2, it will distribute the Krishna water allocated to undivided Andhra Pradesh between Telangana and undivided Andhra Pradesh, which was then undivided in 2000 before 2014. Now between Telangana and Andhra Pradesh. Krishna point in it, Supreme Court about interstate water disputes. Supreme Court criticized the Punjab government for its slow progress in constructing the Satluj Yamuna link canal and asked the centre to conduct a survey of the land designated for the canal to assess the work status. So 1,000 million cubic feet of water can be reliably extracted from a catchment area 75% of the time. Of Krishna water. Then after that we have Krishna Water Dispute Tribunal 2, which was instituted in 2004, which made allocation of Krishna water at 65 dependability and for surplus flow. But in 2014, when Telangana bifurcated from the Andhra Pradesh, now Andhra Pradesh is asking that instead of three states, which are Andhra Pradesh, Karnataka, and Maharashtra, Telangana should be added as a separate state. But Maharashtra and Telangana are arguing that Telangana's share should be taken from the Andhra Pradesh only, not from their share also. Now, let's see what are the factors responsible for interstate water dispute. We have asymmetric access to river water. When a river flows across a boundary between the state, the upstream state is usually at an advantage, creating an asymmetric uh, asymmetry between upstream and downstream. Similarly, in Krishna water dispute, it originates from Mahabaleshwaram, which is in Maharashtra, and Maharashtra is at benefit in it. And we have rising water demand. We have lack of clarity on water usage rights. We have lack of integrated approach. So these are the factors responsible for interstate water dispute. The mechanism to deal with the interstate water dispute under 7th schedule of the Constitution, entry 17 of state list reads water, that is to say water supplies, irrigation and canal drainage and embankments, water storage and water power, subject to the provisions of entry 56 of state list. Entry 56 of list 1 union list. Then we have entry what is entry 56 of list 1 provides that regulation and development of interstate rivers and river valleys to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest. We have Article 262. It says that the Parliament by law may provide for the adjudication of any dispute or complaint with respect to the use, distribution, or control over the water. Regarding Article 264, Parliament has enacted two laws, which is Interstate Water Dispute Act 1956. Under it, a state government which has a water dispute with another state government may request the central government to refer the dispute to a tribunal for adjudication. And we have River Boards Act 1956. Under it, it was made for the setting up of river boards by the central government for the regulation and development of interstate rivers and river valleys. Then we have National Water Policy 2012. It seeks to address issues such as scarcity of water, inequality in its distribution, and the lack of unified perspective in planning, management, and use of water resources. What are the challenges associated with resolving interstate water disputes? We have delayed resolutions. We have ambiguity in Article 262. We have as it deters Supreme Court from adjudicating, and at the same time it causes ambiguity in the implementation of tribunal orders. And also Article 136 empowers the SC to hear appeals against the tribunal order. So here there is huge ambiguity in it. We have politicization of disputes, lack of multidisciplinary approach in it. Our fourth article, it is about the role of technology with public service delivery. Recently, the Comptroller and Auditor General, which is CAG of India, has emphasized on the need for increasing use of IT system and technology service delivery to the citizens. We have technology and linkage with public service delivery. Uh, it How does it affect digital governance services, also called e-governance, are defined as services. These digital government services, these are defined as service delivery within government as well as between government and the public, using information and communication technology. This is the service between the government or within the government departments or from government to public using information and communication technologies. We have traditional government services which have been delivered in person by individual government offices and stand in queues to get their work done. We have e-Hastakshar service facilitates instant e-signing of document online by citizens in a legally accepted form without having to visit government offices. We have increases the efficiency of government departments as the digital records can be shared easily and maintained for later references. We have vehicle data from different state registers are collected and processed in Vahan platform of the Ministry of Road Transport and Highways. This question may be asked: WVAHAN platform, Vahan platform, it comes under which ministry? Ministry of Road Transport and Highways. We have, and it eliminates the ghost beneficiaries and leakages to a larger extent as the digital records can be updated dynamically and the leakages can be traced back easily. For example, the linking of Aadhaar card to the respective job codes of Manrega, likes of ghost beneficiaries were identified and removed. And then it increases the accountability and reduces corruption. This is one of the main advantage of the technology in public service delivery. Then we have consumer protection in India. This is also one of the important topic to be discussed. Let us discuss it. Why it was in news recently. Findings suggest that the dependency in the consumer commission has shown a declining trend from 5.55 lakh in December 2022 to 4.45 lakh in September 2023. There is dependency in consumer commission has shown declining trend. So who is consumer? Let us discuss this. We need to know this definition because there are some points which might be asked in the exam. Under the Consumer Protection Act 2019, a consumer is a person who buys any goods or avails service from a consideration which has been paid or promised or partly paid and partly promised or under any scheme of deferred payment. So this is the definition. This definition applies to whom? It applies to both offline and online transactions through electronic means or by tele-shopping or direct selling or multi-level marketing. However, this is the most important point in it. However, any person who obtains goods and avails service for resale or who obtains goods or avails service for resale or commercial purposes is not treated as a consumer and is outside the scope of CPA 2019, Consumer Protection Act 2009. So this question may be asked in prelims that under the Consumer Protection Act 2019, who is the under the definition of consumer who comes, and this might be in the option a person who obtains goods or avails service for resale. Does it come under this act? So we should know it does not come under this. So as usual, we will go is the need for the consumer protection. In it we have informed choice. There has been an increase in the supply of duplicate defective products in the market. So CPA through its compliance mechanism and rules encourages information dissemination about the product. Information should be shared and people will make informed choice whether to buy or sell it. Then we have misleading advertising. It regulates it to regulate it. Many businesses purposely deceive consumers by presenting deceptive false advertisement, giving consumers an incorrect or partial understanding of a product or service, thus violating the consumer's right to know about what they are buying. Then we have grievance redressal to provide effective redressal mechanism for consumer and address complaints in cases such as the sale of adulterated products, etc. Simultaneously hold the business accountable. We have economic growth and competitiveness. Consumer protection contributes to dynamic and effective markets for businesses to grow. The resultant consumer demand in turn drives innovation and economic development as businesses are required to maintain fair prices and good quality of their product. What are the measures taken for consumer protection in India? We have Consumer Protection Act 2019. Under this act, it provides for the Central Consumer Protection Authority to regulate matters relating to violation of the rights of consumers, unfair trade practices, etc. We have Consumer Protection Rules 2021, Consumer Protection Jurisdiction of jurisdiction of District Commission, State Commission, and National Commission rules 2021 to provide simple, speedy, and inexpensive redressal of consumer disputes. Consumer Protection Act 2019 envisages three-tier quasi-judicial machinery at national, state, and district level. We have CONFONET project. It stands for Computerization and Computer Networking of Consumer Fora in the country. It was implemented in the backdrop of CPA 1986. It aims to improve operational efficiency, coordination, accessibility, and speed in judicial administration, and to set information communication technology infrastructure at Consumer Redressal Commission, consumer grievances. We have e-Dakhil portal. It provides a hassle-free, speedy, and inexpensive facility to consumers around the country to conveniently approach the relevant consumer forum. We have certification markers to protect and sensitize consumers regarding quality standards. Then let's see, we have the last act or last topic which we have to discuss in today's discussion. It is about scheduled tribes and other traditional forest dwellers recognition of Forest Act 2016. So why it was in news recently, states have rejected nearly 40% of the land claims under Forest Act 2000 under Forest Rights Act. So what is this Forest Rights Act 2006? Before this act, that there was no symbiotic relationship between the communities, ST communities living there and the forest, so their rights were deprived. And then this landmark act came, which gave recognition to the scheduled tribes or other tribes living in the forest and their relationship with the forest. It gave them the land holding rights, community rights, and etc. Let us discuss. Earlier acts did not recognize the symbiotic relationship of the STs with the forest and their dependence with forest. We have Section 31A of Forest Recognition Act. It recognizes the rights of the forest dwelling tribal communities, FDSTs, and other traditional forest dwellers to hold and live in the forest land for habitation or for self-cultivation for livelihood. What are the types of rights under Section 3 of Forest Right Act? We have individual forest rights. These are the rights to hold and live in the forest land under the individual or common occupation for habitation or for self-cultivation for livelihood. We have community forest rights. It seeks to restore all customary and traditional rights of forest dwelling communities. It will be within the traditional or customary boundaries of the village, irrespective of the ownership, classification, and size of the forest. Then we have for a community forest resource management right, of ownership, access to collect, use, and dispose of minor forest produce which has been traditionally collected within or outside village boundaries. Which is the nodal agency? These are nodal agencies. As per Act, the responsibility for implementing of the Act lies with the state government or UT administrations. Here we find the role of Gram Sabha. Also, the Gram Sabha is the authority to initiate the process for determining the nature and extent of individual or community forest rights or both. We have land titles in it. This act recognizes the rights of an individual or family or community on the land. However, claim should not exceed more than 4 hectares. Land titles given under the FRA is a legal title. Land rights conferred by the act were heritable but not transferable. They cannot sell it or alienable. Diversion of the forest land from local development rights, establishment of schools, dispensaries or hospitals, Anganwadi centers, etc. They are allowed. We have three-tier approval process in it. Gram Sabha is the primary authority for initiating the whole process by receiving and verifying the claims. Then we have aggrieved person from the resolution of the Gram Sabha. If he is not happy with the Gram Sabha's resolution, may file a petition to the sub-divisional level committee. And if a person is aggrieved, there also any person aggrieved by the decision of the sub-divisional level committee may file a petition to the district level committee. Decision of the district level committee on the record of forest rights shall be final and binding. Scheduled areas in Act means the scheduled areas referred to in Article 244 of the Constitution. Protected areas Forest Rights Act is applicable in national parks, wildlife sanctuaries, and tiger reserves also. What are the concerns related to the land claims related that can be broadly classified into two: land claim related and other concerns. If in land claims related we have document of proof, money, IFR claims, individual forest rights claims were rejected because applicants did not provide adequate documents evidence of the disuse of the land. According to Section 2C of FRA, to qualify as FDST, forest dwelling tribal communities, according to must be a scheduled tribe in the area where the right is claimed and primarily resident in forest or forest land prior to 13 December 2005 and depend on the forest or forest land for bona fide livelihood needs. Then we have inconsistency in acreage claimed and acreage allocated. We have low awareness. The Gram Sabha, which initiates the verification claims, are low on awareness about how to deal with them. An analysis of FRA implementation in Jammu and Kashmir between September 2021 and May 2023 highlighted that more than 92.57% of the rejected claims have been declined by Gram Sabha only. Also, the locals, being illiterate and living in remote areas, do not know the appropriate procedure for filing claims. What are the other concerns in it? In land claim we have documentation proof. It is one of the main concern in it. Then we have inconsistency in acreage claimed and acreage allocated. We have low awareness among people. What are the other concerns? We have forest land encroachment, misuse of Gram Sabha for approval of ineligible claimants, and regularizing encroachments made after 13 December 2005. When the application gets rejected, applicant's file can appeal and case drags on for years and remains encroached. So we have forest land gets encroached. We have violation of Forest Rights Act provision. Earlier titles were randomly issued in the name of communities or panchayat bodies. Then we have lack of coordination. We have destruction of forest and wildlife. So these are the key concerns in this. And what is the way forward in it? Way forward is, the information given there is very much legit and very much accurate, but the way I am expressing it, that might be lacking, and I am improving on it. By time, I promise you I will improve. My way of teaching would change, and I would be able to connect more to you guys. So please, if you are watching these videos, please subscribe to this channel, hit a like button, and I wish best for you guys throughout your life. Thank you very much.